I'll do the microphone.
Yeah. Actually, I am going to leave the microphone here. There's no point in taking it.
Test. It's nothing. Nothing.
Okay. When he pounds it, it's better.
Good afternoon. Good afternoon. Good afternoon. I want to welcome you all to our 10th annual Rosenkranz debate. I noted when we listed the first one, as the first annual debate. That was chutzpah, but it seems to have worked. I want to express our gratitude to the Rosenkranz Foundation for supporting this event for the last 10 years. We love having this Saturday centerpiece for our convention, an intellectually sharp one-on-one debate between two highly prominent legal theorists. The series had a wonderful start in 2008 with a discussion between Judges Richard Posner and Mike McConnell, then Judges Guido Calabresi and Frank Easterbrook, followed by Professors Richard Epstein and William Eskridge. Paul Clement and Larry Tribe debated healthcare. In 2012, Judge Kaczynski and Hardly Acres debated. In 2013, Randy Barnett debated J. Harvey Wilkinson. In 2014, former Attorney General Michael McCasey debated Nadine Strawson. In 2015, Robbie George and John McGinnis debated, quote, "The Constitution was made for a moral and religious people and is indeed suited for the government of no other." And last year, Professors Eugene Volokh and Deborah Rohde debated. To moderate this year's debate and to introduce our speakers, I want to introduce Professor Nick Quinn Rosenkranz, who in addition to his professorship at Georgetown Law School is on the board of the Federalist Society. Nick?
Thank you. Thanks very much. We're delighted that you're here. Gene and I had this idea 10 years ago to have a sort of centerpiece for Saturday of the convention. The attendance was not as great on Saturday as on Thursday and Friday, and we seem to have solved that problem. So we thank you all for choosing to spend your Saturday with us today. We're today debating Lochner versus New York on the off chance that someone in this room doesn't know what that is. New York had passed a statute saying that bakers could not work more than 60 hours per week, and the court held that entering into a contract of that sort was part of the, a contract to work more than 60 hours a week was part of the liberty protected by the Due Process Clause of the 14th Amendment, and thus New York's statute was inconsistent with the 14th Amendment. The case has, as you know, come to stand for an era, and so we'll be debating not merely the case, but the era itself and the doctrine surrounding it. So, and probably we should mention this topic is it's kind of brought more to the fore by a magnificent recent book by David Bernstein, Rehabilitating Lochner. So I urge you all to have a look at that. Now, our resolution today is, quote, resolved. Lochner versus New York, still crazy after all these years. And I generally wordsmith the resolutions myself, but in this year I really have to give credit where it's due. Gene Meyer formulated the wording here, and it's much harder than it looks to be sort of pithy and provocative in just this way, so we have to give credit to Gene, and I'll say it's a particularly remarkable achievement because Gene confesses he is actually the only person on the face of the earth who is unfamiliar with the song. So that's actually quite an accomplishment to have framed it in just that way. So now to introduce our debaters. To my left is Professor Akhil Reed Amar. He's the Sterling Professor of Law and Public Policy at Yale University. I should say I'm going to be brief in these introductions. You have much more detailed versions, I think, in your programs and online and so forth. I just, I want to say personally, Akhil's a great friend and mentor of mine, and it's a particular thrill to have him here doing the 10th annual debate. I took 53 credits as a student at Yale Law School, 19 of the 53 with Akhil, and I believe that's some sort of record, isn't it? And Akhil is, in addition to his many accomplishments and magnificent books, and I'll mention one, you have several here, but I'll mention my favorite, The Bill of Rights, Creation and Reconstruction, I think is maybe the best book about the Constitution in the last 50 years. It's a terrific accomplishment, so I recommend all of his work to you, and I'm thrilled that he's here. I should also say, I'd like to say also he's a great friend to the Federalist Society and a great friend to the Yale chapter in particular. And in addition, he always, every year, year in and year out, makes a point of coming down here to DC to our convention and pretending to disagree with us. And so we're really, we're delighted that you're here. So I'm thrilled that to share the stage with Akhil. By contrast, I have to say I'm distinctly ambivalent to be here with Randy. Now, don't get me wrong.
Let's stop now.
Don't get me wrong, Randy is absolutely brilliant, as you all know, and his accomplishments are hugely impressive, and he's published a number of magnificent books, including Restoring the Lost Constitution, The Presumption of Liberty, and Our Republican Constitution, both of which Akhil has brought. I'm ambivalent, though, because, as you know, Randy is the Carmack Waterhouse professor at Georgetown Law School, where I also teach. And, Randy and I actually usually try not to be in the same place at the same time. We like to leave at least, have a designated survivor so that... so that textualism can live on at Georgetown, if anything untoward should happen. I'm not sure what is going on there while we're both here. I suspect our 126 colleagues are frantically running around the building, finding each copy of the Constitution and scribbling trigger warnings on the top. Our format today is that each debater is going to have 12 minutes for an opening remark. Then we're going to have 7 minutes for reply and rebuttal. Then we'll have a less structured give and take. And then we'd love to take some audience questions. So without further ado, Akhil Amar.
So it's such an honor to be back with you, with my old friends, and I hope some new ones. Lochner. It's, as Nick said, it's a case, it's an era, it's a metaphor, and I think the case on its facts is wrongly decided. The larger philosophy that it embodied is mistaken, and that's what I'll try to defend. So as Nick told you, the law at issue in Lochner was a law that basically prohibited contracts to work more than 60 hours a week as a baker. And you may have been taught that when the Lochner court strikes it down, it does so with a full-blown sort of libertarian liberty of contract theory. And I don't think actually that's the theory that animates Lochner, because the Lochner court is perfectly okay with all sorts of intrusions on individual liberty, laws prohibiting gambling, laws prohibiting prostitution, laws prohibiting unsafe working conditions in underground mines, for example, even when agreed to by adults fully competent. And so that's not what really motivates the Lochner court, a full-blown sort of libertarian theory. And if it did, I think it would be much more attractive. The Lochner court basically sets its face against this law because it thinks it's redistributive. It's trying to help labor at the expense of capital, and that's impermissible, to try to level inequalities of fortune. That's a phrase, actually, that appears in another Lochner-era case, a case called Coppage, and that's why the Lochner court is very suspicious of this law, because it thinks it's trying to sort of help equalize bargaining power and redistribute to some extent the economic surplus that's generated by voluntary transactions from employers to employees. And the Lochner court thinks that's unconstitutional, and I don't. Let me just tell you, the position I'm going to defend is much closer to John Marshall Harlan. He's the great dissenter, a great dissenter in that case, as he was in Plessy versus Ferguson, and in the civil rights cases of 1883, and a whole bunch of other prophetic cases, the income tax cases, Pollock. I will affiliate myself with John Marshall Harlan and not with the more famous dissent of Oliver Wendell Holmes, who's vastly overrated. And on that point, I do affiliate myself, although not on others, with David Bernstein's really interesting book, Rehabilitating Lochner. Holmes should not be your hero. He doesn't believe in rights, liberty, freedom, equality, judicial protection of those things. And I know they don't tell you that at the Harvard Law School quite. So just the facts of Lochner, just so you know, these are facts appear in Harlan's dissent. Just two quick ones. The average age of a baker is below that of other workmen. They seldom live over their 50th year, most of them dying between the ages of 40 and 50. This was actually a genuine health and safety law because actually bakers are working in the dark. They get up, at pre-dawn hours. They're inhaling flour dust all the time. They're not out there in the sunlight, and that actually, that's like being in an underground mine. And there are reasons to have health and safety rules, even if people voluntarily agree to them, because they are putting not just themselves at risk, but their families. And before you have a welfare state, the government is going to have to care for their widows and orphans if they're unable to do so. This is what a commission finds in New York. Quote, the constant inhaling of flour dust causes inflammation of the lungs and the bronchial tubes. So I think it's just a very straightforward health and safety law that is invalidated only because the court actually is really suspicious of that. It thinks something else is going on, which is a certain kind of favoring underdogs, government favoring underdogs in the economy, and the court says that's unconstitutional. And Harlan actually admits, he says, it may be that the statute has its origin in part in the belief that employers and employees in such establishments are not on an equal footing, meaning equal bargaining footing. And I think that's also a permissible government purpose. Now, why do I think that? Because Because you could read the takings clause very broadly and say, gee, that's improper, even though it's about real property or property generally, it signals a general anti-redistribution principle. You could try to read the no obligation of contract, impairment to the obligation of contract clause that way. One originally applied only against the states, one only against the federal government. You could read them very broadly, but if you are, read the Reconstruction Amendments broadly also, because you see the 13th Amendment is redistributive. It takes property, lawful property, from slave masters and redistributes it to the slaves themselves. It does so in the name of a fuller sort of dignity, liberty, equality. And these aren't just traders, you see, that it takes property from. The 13th Amendment takes lawful property from lawful masters who fought for the Union Army in places that never seceded, like Kentucky, that were slave states. That would be John Marshall Harlan's family, just in case you missed it, because his was a slaveholding Kentucky family, and the 13th Amendment redistributes property permissively. And the 14th Amendment actually says, emphatically, there's going to be no compensation for slaveholders, Section 4, who lost their property in slaves, and we're not going to actually do any redistribution for that. So I think modest redistribution of a certain sort is not an impermissible purpose. Health and safety laws are not impermissible. And even if you don't think that, in 1905, you see, so Lochner is less crazy then than it would be today, because in the interim, we have a 16th Amendment, and the 16th Amendment, the Income Tax Amendment, was designed to provide for not just an income tax, but a redistributive income tax, and everyone understands that. The income tax, and the first important federal one is signed by none other than Abraham Lincoln, and it's a redistributive tax. According to Treasury Department estimates, less than 1% of the population had been subject to it. And here's actually, and both parties support an income tax amendment, and they understand it's redistributive. Here's the Democratic Party platform of 1908. We had a great national conversation about this. We urge the submission of a constitutional amendment specifically authorizing Congress to levy and collect a tax upon individual and corporate incomes to the extent that wealth may bear its fair share of the burden of the federal government. So modest redistribution of a certain sort is as American as apple pie, as constitutional as the Constitution itself. The 16th Amendment, 13th Amendment, 14th Amendment, Section 4. Now moving forward in time, because I'll let you, we're a small group, we're just among friends here, I'll let you in on a secret. I actually have strong libertarian sensibilities. And Lochner isn't quite a libertarian case. I think it's a propertarian case. And I think my friend Randy, and here are a couple of his books, and I do commend these to you because they're really powerful and interesting, and I've learned a lot from them. I think there's some mistakes in them, and we can talk about what those might be, because he tries to defend Lochner on 14th Amendment originalist grounds, and I have some doubts about that. Maybe in the second round we can talk about that a bit. But here are some things that Randy has stood for and that I agree with. But I think he actually said, people who are desperately ill and they're undergoing cancer treatment, let's say, and medical marijuana can alleviate their pain. Should government be allowed to prohibit that? Now, that's the Raich case. Now, he framed it as a federalism case. And I think as a federalism case, I respectfully disagree with his argument. But if he had framed it just as a straight-out liberty idea, and then states couldn't prohibit this either, I would have found that quite...
That was our other count.
I would have found that quite persuasive. How many minutes do I have left about?
Maybe 2.
Okay.
Yep.
So let me mention one. I'll give one other shout out now, here's why I disagree with him. I do not find Obamacare an egregious law. It had an individual mandate, but you see, as a matter of liberty, if that's the problem as a matter of liberty, Romney Care was unconstitutional, or a violation of liberty, or all sorts of other state laws that require insurance for all sorts of purposes to drive a car. And you could say, well, you don't need to drive a car. Well, good luck in California, without a car, or in Texas. But if government can tax me, and it can, if it can buy stuff with the money it gets from me, and it can, and if it can give that to me, and it can, why can't it say, it's a matter of liberty, Amar, get it yourself? I don't really see that as a distinctive threat to liberty. But there are modern cases that I think are libertarian in more attractive ways. Griswold is one. But it's actually liberty and equality, because you see privacy, unlike property, is a little bit more equally distributed. One person, and it's not quite one person, one vote. It's like one person, one bed. You can only be in one bed at a time. That's true if you're Bill Gates. That's true, if you're a pauper. It's more evenly distributed. So, so I think privacy brings the best of liberty and equality together. Let's take one other example, and then I'll end, where I think Randy and I have some common ground. In the Heller case and City of Chicago versus McDonald, applying these right against the states, both Randy and I and the great Eugene Volokh, who was here yesterday but isn't here, believe, and I think actually I was on record first, in fact, way back in that Bill of Rights book, there's a right to have a gun in the home for self-protection. And that's as a matter of liberty. And everyone can have it. It's not that expensive an item. And my liberal friends sometimes, I think, are a little bit intolerant in that way. They understand, the right to have, they believe in sex in the home, but not guns in the home. And I say, this is America, let them both have what they want, Personally, I prefer sex, but whatever floats your boat. And we my wife hates it when I say that. But we're just among friends here. We don't need to, spread the word. So Randy and I have a lot in common. Griswold, yes. Heller, yes. City of Chicago versus McDonald, yes. Lochner, not so much. And Gene, you really should hear I'll end, the Paul Simon album, not just the one song. And there's one, actually, since you mention it, there is one song on the album, 50 Ways to Leave Your Lover. There are many ways to leave Lochner. Many pathways, and you should pick one.
Professor Andy Barnett.
Well, that was awesome. I'm so glad that Akhil decided he was going to defend John Marshall's dissenting opinion and not the egregious Holmes dissenting opinion, because it's a much easier thing for him to do. If he'd have chosen to defend Holmes's dissenting opinion, then he would be no different than J. Harvey Wilkerson, who I debated here 5 years ago, and we would just have to repeat that debate all over again, and that would be very boring. So this is actually a much more reasoned debate. I'm going to approach this textually, as I know Akhil also likes to do, and talk about Lochner as first of all, as a due process clause case, and secondarily as a privileges or immunities clause case. As you know, Lochner does use the due process clause. It has been falsely characterized as applying what is now called substantive due process, meaning taking certain rights, identifying them as fundamental, elevating them to some heightened status, a very heightened status, subjecting any laws to strict scrutiny, which those laws typically don't pass. And that is not at all what the Lochner court did. It does talk about liberty of contract, of course, but it doesn't do modern substantive due process. The term substantive due process itself was a term of opprobrium that was generated by progressives to criticize the Supreme Court. It wasn't the term the court used, and it wasn't adopted by the Supreme Court until relatively recently. No, I think what the court was using here was the due process of law clause. We normally call it the due process clause, but it's the due process of law clause. And what the due process of law clauses in both the Fifth and the 14th Amendment say is that no person can be deprived of life, liberty, or property without the due process of law, meaning it has to be by a valid law. And in this case, Joseph Lochner was deprived both of property and of liberty. He was fined for his breach of the Bake Shop Act, and then he was jailed for failing to pay that fine. And so he was being deprived of his liberty at the time under this supposed law. And then the question is, was it really a law? Or, as Samuel Chase said in Calder versus Bull, an act of the legislature, for I cannot call it a law, contrary to the great first principles of the social compact, cannot be considered a rightful exercise of legislative authority, a rightful exercise of legislative authority. So we have to ask ourselves, under the due process of law clauses, is whether the relative legislature was rightfully exercising their legislative power. So if we're talking about a federal law, like the Affordable Care Act or like the Controlled Substances Act, we would have to ask, we would have to evaluate the substance of the law to see whether it had been authorized by an enumerated power. That would be both in the case of Commerce Clause, for example, it would be both a Commerce Clause challenge, and it would also be a due process of law case, because it's the due process of law that gives individual persons a process or procedure by which they may challenge a law being imposed upon them as not being an actually valid law. So every Commerce Clause case is also a due process of law case as well, and it's true here as well. And of course, the 14th Amendment speaks of states, and so we understand, I mean, Federalist Society members, I think, are pretty much on the same page about where they're going to find the powers of Congress. Now, what about the powers of states? What would make an act of the state legislature a wrongful act? Well, the 14th Amendment, as you know, also includes the Privileges or Immunities Clause, which says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So to see if a law that's being imposed upon someone and they're being deprived of their life or liberty because of that law is in fact an appropriate law, we must ask if it abridges the privileges or immunities of citizens of the United States. So what are those privileges or immunities? To understand that question, we must begin with George Mason's draft for a Bill of Rights or a Declaration of Rights in Virginia. And I always prefer to begin with George Mason's draft, not the actual adopted version, adopted 2 weeks later by the Virginia Provincial Convention, because the version, they watered it down a little bit for reasons that I might mention. So here's what George Mason said. This is how his Declaration of Rights begins. That all men are born equally free and independent and have certain inherent natural rights, of which they cannot by any compact deprive or divest their posterity, among which are the enjoyment of life and liberty and the means of acquiring and possessing property and pursuing and obtaining happiness and safety. This was the canonical reading or rendering of natural rights. Jefferson had it in front of him on his desk when he was writing the Declaration of Independence some 2 weeks after this draft was written. It was adopted in various similar formulations by the states of Massachusetts, New Hampshire, Pennsylvania, Vermont, in addition to Virginia. And in Massachusetts, we know, it was considered to be judicially enforceable, because it was this language that was used in 1783 to hold that slavery was unconstitutional in Massachusetts on the basis of this language. What the court said in the Quock Walker case is that, among other things, without resorting to implication, the court said, in constructing the Constitution, the slavery is, in my judgment, as effectively abolished as it can be by the granting of rights and privileges wholly incompatible and repugnant to its existence, referring to the very same wording that George Mason had adopted. James Madison, when it came time to draft the Bill of Rights when Madison was a congressman, James Madison proposed that this very same language be added to the preamble of the Constitution, because initially they didn't realize that the amendments were going to go at the end. They thought they were going to be inserted within the text. And here's what he proposed be added to the preamble: that government is instituted and ought to be exercised for the benefit of the people, which consists in the enjoyment of life and liberty, with the right of acquiring and using property, and of generally of pursuing and obtaining happiness and safety. Exactly George Mason's words. Madison wanted in the preamble. And when he gave his Bill of Rights speech, his so-called Bill of Rights speech, he had a whole list of amendments, including this one for the preamble, and it was what he wanted to add to the preamble that he said the following of. He says, the first of these amendments relates to what may be called a Bill of Rights. When Madison used the term Bill of Rights, this is what he meant. And Akhil is one of the earliest scholars to realize that in fact the term Bill of Rights was not initially used to describe the first 10 amendments of the Constitution. I mean, Akhil really blazed the path here. It was not a phrase that was associated with the first 10 amendments till at least after the Civil War, and I think more recent studies have shown it wasn't until the 1920s or 30s that the first 10 amendments came to be called the Bill of Rights. What was called the Bill of Rights was this George Mason language about the importance of fundamental natural rights, and, as Madison said, that government is instituted and ought to be exercised for the benefit of the people, which consists in the enjoyment of these natural rights. So, bringing us closer to the 14th Amendment, we noted in the original Constitution there is a Privileges and Immunities Clause in Article 4. And what are the Privileges and Immunities Clause? Well, the canonical case was Justice Bushrod Washington's Circuit Court opinion in the case of Corfield versus Coryell in 1823. And here's how Justice Washington described the privileges and immunities. That government, and it's a very long passage, but the relevant passage is here, that government is instituted in, protection, here's the privileges and immunities. Protection by the government, the enjoyment of life and liberty, with the right to acquire and possess the property of every kind, and to pursue and obtain happiness and safety. You will recognize this as Mason's formulation. And also later on he says, to take hold and dispose of property, either real or personal. This was the language that was used repeatedly by those who drafted and defended the 14th Amendment and the Privileges or Immunities, and explained the Privileges or Immunities Clause. Not only did they cite Corfield versus Coryell, they repeatedly quoted this passage from Corfield versus Coryell, including Jacob Howard, who was the sponsor of the 14th Amendment in the Senate. And when he was asked to say, well, what are the privileges or immunities of citizens of the United States, he read verbatim this opinion from Justice Washington in Corfield versus Coryell, and then he added at the end of that, to these privileges and immunities, whatever they may be, for they are not and cannot be fully defined in their entire extent and precise nature, to these should be added the personal rights guaranteed and secured by the first 8 amendments of the Constitution. In other words, for Howard, first came Corfield versus Coryell rights, and then secondly came the rights that were enumerated in what we now call the Bill of Rights. Finally, the final piece of pre-14th Amendment evident text that I will read to you is the wording of the Civil Rights Act of 1866. You will notice so far I've been talking about property, although this includes the right to dispose of property, which would be by contract, of course, but I haven't mentioned contract. The Civil Rights Act of 1866, when it was establishing what the rights of the freedmen would be, in fact, what the rights of all persons would be, said the following, included the following amongst those rights. The rights to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property. This provision, this statute, was passed under Congress's 13th Amendment power. The second article of 13th Amendment gave Congress the power to implement the 13th Amendment. Some in Congress, including John Bingham, questioned whether Congress truly had the power to enact this statute under the 13th Amendment. And it was for that and for a bunch of other reasons the 14th Amendment was enacted. And just to make sure, Congress then repassed the Civil Rights Act after they adopted the 14th Amendment to ensure its constitutionality. It was the Privileges or Immunities Clause, and combined with the other 2 clauses in the Section 1, and the Citizenship Clause as well. So it is absolutely no doubt, I think, historically, that the right of property and contract are among the privileges or immunities of citizens of the United States that states cannot deprive, and the due process of law allows people to challenge laws that take away their liberty or their property if they violate one of these privileges or immunities. But then what? Then what? Because I deny that the Lochner court used strict scrutiny or anything like strict scrutiny, I agree with Akhil. What's called the Lochner court, and in fact that was a term that didn't get invented until Jerry Gunther started calling it the Lochner court in the 1970s, believe it or not. Because the Lochner court did uphold a lot of regulations, the ones that Akhil said to be sure. But here's another regulation it upheld. It upheld the regulation of the bake shop industry. Because, in fact, there was a very elaborate code enacted called the Bake Shop Act, which regulated the minutiae of the bake shop industry, including, for example, the height of ceilings, what the composition of the floor should be, where the washroom facility should be. All of this was upheld by the Lochner court in Lochner. in Lochner itself. You can actually open up the opinion and see all the provisions of the Bake Shop Act. There was only one provision of the Bake Shop Act that it questioned. And it questioned it because, which was the maximum hours law, which had been added to the bill by the Bake Shop Union. It came into the bill somewhat separately from the rest of the Bake Shop Act. And it questioned on the grounds, by employing what came to be the traditional way of evaluating whether a law was a police power regulation was within the power of the legislature to enact, and that is to ask whether the law was irrational or arbitrary. And I'm just about out of my time, so I'm not going to be able to say too much more about that. Maybe I'll say more in the rebuttal, but I will say they found the law to be arbitrary, in part because it was only being applied to bakers. And they looked at the appendix that had been filed by Joseph Lochner, which included a lot of social science research at the time, primarily involving the English bake shop industry, which basically said the bakers weren't any particularly more dangerous an occupation than any other occupation, than many other occupations. And by singling out the bake shop workers, that was an arbitrary exercise of power. Here's somebody else it didn't protect. It didn't protect bake shop owners, who were allowed to work more than 60 hours in the very same conditions that the bake shop workers were being allowed to do. If it was really so unhealthful, why were bake shop owners allowed to do the same thing? So it was irrational. It was arbitrary in that sense, and it was irrational because there was an inadequate evidentiary support for it being a genuine health and safety law. Justice Harlan did, in fact, disagree with that on the facts. So there is that good faith disagreement, I believe, between the two approaches. But I think they also adopted a different presumption. I think the majority said the burden of proof was more or less on the legislature to establish, and then Justice Harlan wanted to adopt a rebuttable presumption of constitutionality. So for all these reasons, I submit that Lochner v. New York, or a case like Lochner v. New York, was not crazy or would not have been crazy in 1868 when the 14th Amendment's Privileges or Immunities Clause and Due Process of Law Clause was adopted. It was not crazy in 1905 when it was decided. Indeed, it was generally supported by newspaper editorials at the time. It did not become a public issue until Theodore Roosevelt made it a political question when he ran as a progressive party candidate in 1912, and he criticized the bake shop case, and he praised Holmes, who Roosevelt had put on the Supreme Court. And it would not be crazy today if courts realistically examine regulations to ensure that they are neither irrational nor arbitrary restrictions on the liberties of we, the people. Thank you.
Akhil, 7 minutes to reply.
So I think the zone of disagreement is actually more modest. I want to just persuade you this is not remotely an irrational law. I'll go back to what Harlan does say, just once again, because are bakers any different from anyone else, or is this a particularly dangerous or unhealthful employment? Is it more like working in underground mines where there are all sorts of safety rules, and employees might be willing to sign up in violation of them in order to get more money or something, and we don't let them do that, in part because they put their families at risk and the rest of us are at risk if we have to rescue the mines and all the rest. So here's what Harlan says, and I just want you to hear this. The average age of a baker is below that of other workmen. They seldom live over their 50th year, most of them dying between the ages of 40 and 50. Now maybe this hits me particularly hard because I'm, 49. and so I think, oh, wow. And it's not just about their health, it's about the healthfulness of the bread that they're producing for consumers. This is a food and drug consumer safety law, because if they're so tired and bleary-eyed, that's a public health concern. Now, for every law, now what the government says is, and Harlan says, if it had been 16 hours a day that was prohibited, surely that wouldn't be irrational. And now we're just kind of talking about, what is a reasonable zone. The court says, well, why is 10 hours a day good enough, but not 11. You can do that for every law. It's like, when Yogi Berra said, gee, if we only move first base a foot, we could get rid of all the close plays. So that can't be the test. It can't be the test if we're actually asking, is it reasonable? Is this rational? Is this law-like? Or is this fiat, arbitrary, just some diktat? It can't be true that just because we actually have special accommodations for people who are self-employed, in part, it's hard even just on an accounting basis to figure out when they start and when they stop. They don't punch in the way employees who work for others are. So no law has one and only one purpose. There are a cluster of purposes, and when you combine their health concerns of the workers with the concerns of consumers who may or may not know just by inspecting the bread whether it's been produced by someone who's bleary-eyed or paying attention. And an additional concern that we might want to actually have special accommodations for people who actually choose to be self-employed. They're different in all sorts of ways from a bookkeeping perspective and a regulatory and a tax perspective. Perfectly reasonable law, it seems to me. Now, since Harlan has been mentioned, and we are both, I think, John Marshall Harlan people, I think just maybe let me tell you one other really famous dissent of his and what was going on in that case. That's another case out of New York, the Pollock versus New York case, 10 years before Lochner, where the Supreme Court invalidates an income tax. And Harlan, it's 5-4, just as Lochner is, and he says this is going to be a real disaster for the country, and I think he ends up being right about that. And remember, he's the great dissenter in Plessy versus Ferguson, and he believes in the incorporation of the Bill of Rights against the states, and Holmes doesn't, and believes in broad protection of freedom of expression in a case called Patterson versus Colorado, and Holmes doesn't. Why did they think that this law that Abraham Lincoln had signed into law, an income tax law, was unconstitutional? Basically because it's redistributive. And that's why a lot of people don't like Obamacare, because it's redistributive, and it's hard to do redistribution at the state level because the fear is that poor people will move in and rich people will move out. And the federal income tax was designed to be modestly redistributive, a high exemption, which today's Republicans believe in, and actually tiered rates, which even today's Republicans agree with. It's not a totally flat tax. And the Pollock court thought that was unconstitutional because it was redistributive. That's actually, the deep idea of the Lochner era is, as I said, it's not purely sort of libertarian. It's a little too propertarian for my taste, and not quite libertarian enough. I actually end early to give us time more just for back and forth conversation.
Randy, 7 minutes.
Right. Well, we do agree about a lot, but here's the problem. If the modern anti-canonical reading of Lochner is taken to be true, coupled with the Slaughterhouse case, which Akhil strongly believes was wrongly decided.
As do you.
Right, we both do. He said that no serious scholar, left, right, or center, thinks it was rightly decided. Yeah. There's been a couple that have come out since you wrote that that we would both agree are serious scholars. But with those two caveats.
Who are they?
Well, Kurt Lash would be one of them.
My student.
Well, your student. Your student.
And friend.
Yeah. Apart from, we both agree that Slaughterhouse was wrong. But thanks to Slaughterhouse, and thanks to the modern reading of Lochner as being in the anti-canon of being a terrible, awful case, none of the facts that Akhil has just so passionately articulated are relevant to a constitutional challenge, because it's Holmes's opinion that has been accepted as the correct approach to the Lochner case. And as a result of that, as a lawyer, you couldn't introduce evidence of any of that in court. It would just not be litigated. No judge would ever pass upon the correctness of who's right, Akhil or me, when it comes to the particular facts of the bake shop case. And actually, we don't really care today about the facts of the bake shop case. We care about the methodology that grows out of the Lochner court and its misinterpretation. And so then at that point, what separates us is whether we favor the majority approach, the Rufus-Peckham approach, which basically gives creates a presumption of liberty on behalf of each individual person and puts the onus on the legislature to justify its actions as rational and not arbitrary, or whether, as Justice Harlan would have had it, we put the onus on the challenger to establish that the law is irrational or arbitrary. I could very, very easily live in a world where there was a rebuttable presumption of constitutionality, not the irrebuttable presumption of constitutionality that was established in Williamson v. Lee Optical by the Warren Court, and that was the first time that Justice Holmes's approach became the majority approach of the Supreme Court, as it is up until today. And so that would be a pretty good world. That would be a much better, and I would say somewhat more libertarian world than the one we currently live in, if laws had to pass Marshall scrutiny. But here's one of the consequences of the way that Lochner has been interpreted, or of that way of interpreting it. And it is, and Plessy versus Ferguson is a good example of that. After the Slaughterhouse case basically adopted, that was something that sounds a lot like what Holmes was eventually getting at, by eliminating the Privileges or Immunities Clause, when it came time to evaluate whether a law that segregated streetcars and railroads was irrational and arbitrary, the court adopted the Holmesian view. The court adopted the new modern anti-Lochner view, and that is simply deferred to the legislature. And no factual inquiry was done by the Plessy court in deciding whether there really was a social problem that needed to be addressed by the segregation of the races. They simply assumed that the legislature was acting in good faith, and in one paragraph, they dismissed the challenge. It was Justice John Marshall Harlan who dissented in that case by himself, which is why when I'm asked to state whoever my heroes on the court, I have very few heroes amongst the Supreme Court justices because they've all made egregious mistakes at one time or another. It's hard to get behind any one of them. If I have to choose one justice who I say I admire the most, it is Justice Harlan. Because of his work, his rulings in the civil rights cases, as well as Plessy versus Ferguson, and also because he took a more moderate view in Lochner than the courts would do today. So I don't think this is the place to litigate the facts or science, and oftentimes it was junk science behind progressive legislation of the kind that was at issue in Lochner. But I think that the Lochner court was probably acting reasonably. I'm sure it was acting reasonably when it upheld the rest of the Bake Shop Act. All that was issued was whether this law was in fact being passed by what the court referred to as other motives. And Akhil characterizes this as redistribution. You could characterize it that way. I think it's more accurately characterized as class legislation, which is the way the courts viewed it back in those days. That is, attempting to help to sort of advantage one group of people because they found favor at the legislature as opposed to another group of people. In this case, it would be labor unions on the one side, not all workers, by the way, labor unions on the one side, which had promoted this particular law, and non-unionized, mostly ethnic German and Jewish bake shops, both in the city of New York and also in remote towns in New York, which is where Joseph Lochner actually had his bakery. And those were non-unionized bake shops. They did not want to be unionized. And by siding with the bake shop union, it not only sided with the union, it sided with the big mechanized industrial bakeries that could afford to be unionized when the small mom and pop immigrant bakeries could not. So that is what the court suspected was going on. Maybe they were right, maybe they were wrong. This is not the place to litigate the facts of Lochner. This is the place to show that Lochner v. New York wasn't crazy the day it was decided. It was not thought to be crazy the day it was decided, and it would not be crazy today to revive realistic scrutiny as to whether legal restrictions on our life, liberty, and property are irrational or arbitrary.
So terrific. That's the more structured part of our program. And now I'd like to invite our debaters to engage with what each other said in a maybe more unstructured way. And maybe to start us off, Akhil, if you would like to speak to Randy's last point. So is this properly characterized as redistributive, or is it really properly characterized as class legislation and doesn't matter?
I think there may be two ways of saying the same thing. That I talk about whether it's okay for government to side with underdogs to try to equalize bargaining power. The court, especially in the Coppage case, says that's per se unconstitutional. That's an improper government purpose. And I'm thinking, well, you know, siding with, for example, former slaves against slave masters. That's what the 13th and 14th Amendments were in part about, trying to create a Republican citizenry by mitigating extremes at the bottom and the top end of a socioeconomic structure in order to create a great middle class, to use a modern phrase, that would be the backbone of a Republican citizenry. We do not, for example, auction off land in the West to the highest bidder. We don't use market mechanisms. We have 160 acres in a Homestead Act. I think it would have been perfectly okay for there to have been redistribution in the South from the plantation owners to the people who really worked that land and made it valuable. 40 acres and a mule in the South. This was actually the 14th Amendment framers' vision, 40 acres and a mule in the South, 160 acres in the West, a moral land grant act that actually uses government property to, uses government resources to try to create access to education and bring the bottom up. In more recent times, a GI bill, and these are modestly redistributive, and that's what the Lochner court, actually, the Lochner era judges sort of set their face against, and that's, as I said, you can see that most prominently in the income tax case of Pollock v. New York. This is a very personal case for me, Pollock versus New York, because the fellow that came up with the theory that an income tax was unconstitutional was a man named Charles Southmaid, Choate Holland Stewart. The Southmaid, he was a Yale Law School graduate. Southmaid family is very, very generous to Yale. It endowed a professorship in Charles Southmaid's name, and yes, you guessed it, I was originally the Southmaid professor of law, and writing these attacks on the Pollock case and the Southmaid theory, so no good deed goes unpunished. So I do think, and one other way of putting it is, look, here's what the Lochner court is not actually opposed to, and a proper libertarian theory might. So why don't you get to actually gamble, especially if you're not gambling away sort of everything? That's what a contract is. It's a gamble. I'm betting, you know, that the price of something will go up, and you're betting it that it's going to go down. That's the stock market, or that's also. But gambling is prohibited. If you really have a right to your labor in all respects, why do we have health and safety laws about underground mining or all sorts of other things? Are all minimum wage laws unconstitutional? They do sort of interfere with pure freedom of contract. All drug laws of all sorts, at least among adults, unconstitutional. Prostitution and other laws. So this is not the law today. It's not the Lochner court vision. They saw certain laws, they looked at that and they basically saw socialism. The Lochner court asked the question whether this is, quote, a labor law pure and simple. That's their phrase. And by that they meant kind of labor with a capital L against capital with a capital C, or maybe I should say a capital K. They are seeing in this the thin edge of a sort of a socialistic wedge, and I think they do overreact. So. And actually, and maybe this concedes the debate to Randy. It's not crazy to think so, but it wasn't crazy.
All right, we can go now.
Of the legislature to have adopted this law. And remember, he says his hero is the dissenter in Lochner, the great John Marshall Harlan. Maybe in the next back and forth, I'll tell you why I agree completely with Randy and with David Bernstein in their critique of Holmes, and tell you more reasons why Holmes should not be our hero, but John Marshall Harlan should.
Randy, you should respond to anything you like that Akhil has said, but let me draw your attention to a couple of points. So Akhil has emphasized this, that the regulation of the miners was all right, and the court was at pains to distinguish that case. And is that an important distinction or not? And how should we think about that? And Akhil also urges us to think about all the paternalistic or moralistic laws that were held to be all right, like prostitution, like gambling, et cetera. How should we think about those?
Right. These are all good questions, tough questions to answer in the limited time I have. I'm old enough to remember mining disasters happening on a regular basis when I was growing up. We don't have that anymore, thankfully, partly, I think, because of the regulation of the mining industry. But in fact, I can see other people in the room who are old enough to remember mining disasters. Mining can get extremely unsafe below ground if people are tired and they're not able to pay careful attention to what they're doing. It's a very hazardous and was considered by the court to be an extra hazardous occupation. The Lochner court, the judges in the Lochner court didn't think bakers were in that category, and they mentioned a lot of other occupations that were actually stressful in the way bake shops were stressful. But I think it's a mistake to get too wrapped up in the particular facts of this case and to try to re-adjudicate the facts of this case. What's really at issue with Lochner v. New York today, the reason why it's of interest to the people in this room, is because it stands for, the reaction to Lochner stands for the proposition that judges have no role in scrutinizing whether a particular restriction on life, or liberty, or property is in fact an irrational and arbitrary one because it's not suitably related to an appropriate state purpose of the kind that they used to call competent, something that the legislature was competent to. Health and safety was acknowledged at the time of the 14th Amendment, and from the founding all the way through the 14th Amendment to today, to be a perfectly appropriate end of government regulation in order to protect the natural rights of the citizenry. And that health and safety laws did it. And so too, for example, were the laws that regulated public morality, moral behavior that took place in the public sphere, where people who might involuntarily come upon those activities like prostitution in the streets or gambling halls or other sorts of notorious and public nuisances is how they were referred to, as opposed to moral behavior behind closed doors, against which there were some laws, but those laws were hardly ever enforced by the state and therefore rarely, if ever, tested legally. So yes, there are appropriate governmental ends. The question that Lochner poses to you in this room today is whether you believe judges have a role, as both the majority and Justice Harlan believe. Judges have a role in policing the outer boundaries of legislative discretion to make sure that that legislative discretion is being exercised in good faith. That is, it's good faith efforts to secure the health and safety of the citizenry. And it was the good faith of the legislature that the Lochner majority was skeptical about whether this one provision buried in an otherwise appropriate health and safety regulation was really being exercised as a good faith method of protecting the health and safety of the public, or really whether it was being passed for other motives about which legislatures were not competent.
Randy, what's your thought on just the constitutionality, not the wisdom? I might be actually with you on the wisdom, especially at a certain price point, of minimum wage laws.
Minimum wage laws, certainly when the minimum wage cases were first decided, as you know, minimum wage laws were first only applied to women. And they weren't applied across the board. And that is the minimum wage laws that were first invalidated on the grounds that they were arbitrary. And in fact, they were a means of disadvantaging women in the marketplace when competing with men, because women, it was thought, could undercut the wages of men, since women could basically make their own salary possibly as a second income, whereas men had to support a family, and therefore women would undercut them. And that's why it was thought that's why labor unions supported minimum wage laws for women. And when it comes to minimum wage laws across the country, I do think that's an interference with freedom of contract. And in fact, as we all know, the minimum wage, the real minimum wage, is zero. Because if you raise the ostensible minimum at all, and then you'll have no wages whatsoever.
So they would be unconstitutional, you would think?
I'm not going to say whether I think that they're unconstitutional. I would have to see that they would have a connection to an appropriate legislative purpose. I'm not exactly sure I would see what that appropriate legislative purpose is, but that's the way I would structure that argument.
How about...
And in fact, with controversy, and then that record has to be impartially adjudicated by a judge, or if you're talking about the constitutionality of a particular statute, I would favor going back to the old practice in which only 3 judge panels could invalidate a law for being unconstitutional. That was what the Williamson v. Optical lower court was. It was a 3-judge panel of a circuit court judge, the presiding judge of the district court, and a district court judge. And the 3 of them had to find a law was unconstitutional. But they were fairly adjudicating the evidence that they heard in Williamson v. Optical. That's what I would like to see happen with every case that restricts the liberties of we the people. We're not talking about wrongful behavior. We're simply talking about the reasonable regulation of rightful behavior, and that's what needs to be adjudicated if challenged.
And the other question is, because these are really interesting questions, today, as a matter of infringement of liberty, let's just say general anti-discrimination laws in, let's say, employment. I'm not talking about serving customers or other people, just in general employment anti-discrimination laws, which does limit the ability of the employer to choose as the employer sees fit.
Well, I said I wasn't going to answer any more hypothetical questions.
You can, and if you like, you can pose one.
That you do, because I've always thought that's a particularly important paragraph. Since Randy mentioned the Bill of Rights, suppose we didn't have the Bill of Rights at all. We would have to think about a lot of what government does, thinking about government pretext. So, for example, you know, an article in commerce that's bought and sold across state lines. Well, ordinarily it could be regulated or prohibited if it's a diseased a piece of fruit or defective table or lamp. But suppose government said, you know, we're going to prohibit the interstate shipment of opposition newspapers. And this is a regulation of the channels of commerce. We're going to do this in 1789, and we don't yet have a first. Today we see that's a violation of the First Amendment, but we don't have a First Amendment, you see. And we would have had to have a jurisprudence that that's not really what that's not a proper, a necessary and proper hat tip to Gary Lawson
and Patty Granger.
But a step beyond Gary Lawson, because I'm not talking about, in his terminology, an executory law. I'm talking about actually even if it were done straight under the interstate commerce clause and not under the interstate commerce plus the necessary and proper clause. We would actually have to have an analysis of motivation, as the colonists themselves actually did in the great federalism debate that was the 1760s and 1770s, because they admitted that Parliament could regulate for certain purposes of imperial benefit, but they actually denied that Parliament actually could try to tax them, which required them to inquire into the purpose. Was the Townshend duties really actually a proper, legitimate regulation of imperial trade, or was it actually an attempt to raise revenue, which you shouldn't do without the consent of the people being taxed? So we have to do it when it comes to race. We have to do it when it comes to free speech. So yeah, of course you need a proper pretext analysis. My claim is the fundamental one, that a law designed to favor the have-nots at the expense of the haves is in general not an improper purpose, even when, given the spirit and intendment of the Reconstruction Amendments. That's and especially as reinforced by an income tax amendment that is understood by everyone, whether they're for it or against it, as blessing the permissibility of certain kinds of redistribution, because the tax is going to be a soak the rich redistributive tax.
So I have a question, Akhil, that along that lines, and we agree entirely on the use of proper and pretext and the importance of the McCulloch language. But at the state level, do you think it's an improper purpose for a legislature to enact a so-called economic regulation in order to benefit a certain subgroup that is politically well-connected and perhaps makes campaign contributions? Would it, for example, be appropriate motive to help out the ophthalmologists and optometrists at the expense of the opticians? And if that's the case, what sort of inquiry is justified under the Due Process Clause in order to ferret out the bad motives, or what the Lochner court called the other motives, in a lower court proceeding?
Excellent, and unlike you, I won't dodge hypotheticals. I'll answer them. Just saying. I think we want to distinguish two things, and Randy, in his writings on this, is exquisitely, acutely attentive to this important question about the judicial role. So he says, you know, one question is really on whom you put the burden of proof in a case like Lochner, and that's actually a rather significant theme of this book, which I do commend to you all, and this one also.
Although, Akhil, just to be fair, in that book I do praise Harlan in his dissent, and I say it would be better if we had Harlan's approach today.
Yeah, no, I'm saying nice things about your
right.
books. Don't fight me. I haven't told them the mistakes yet. But if you push me,
is that the first edition or the second edition?
No, this is the paperback. Okay, there's no excuses here. We might want to distinguish between things that are actually not constitutionally proper, in a Platonic sense, and the judicial role, and what judges are good at and not good at. And this is John Ely's book, A Democracy and Distrust. Its subtitle is A Theory of Judicial Review. This is Caroline Product's footnote 4, which is not about opticians and optometrists and ophthalmologists, Williamson versus Lee Optical, but the earlier case about synthetic milk and whole milk. And it might very well be that judges don't need to intervene that much to protect, one, fairly well-organized group, opticians or optometrists or ophthalmologists, against other equally well-organized groups. I'm not at all sure that that the judicial scrutiny economy is best served, because there are only so many things that judges can do. I want them to focus a lot on smoking out race discrimination and political viewpoint discrimination and gender discrimination. These are actually central things in the 14th Amendment. I'm not sure that they actually need to be as skeptical as the majority was in Lochner of a law, as I said, designed to basically help employees at the expense of employers. And I understand that there are going to be differences among employees, and they're not all always going to be on the same page. But it seems to me that the owners are able to pretty well to protect themselves in the legislature, and I don't see that the 13th and 14th Amendments were all about protecting against minimum wage laws.
I think Randy, last 30 seconds, and we're going to take some questions.
I think this is a distortion of how things actually go on. Sure, some people are well organized, but the kinds of challengers that, for example, the Institute for Justice brings concerns the individual florist or a hair braider, or somebody who does animal massage. These people are not people who are organized, and they are up against organized, entrenched interest groups who have the ear of regulators that they tend to capture. And what the modern, and my goal here isn't really to debate Akhil. My goal here is to convince the people in this room that their vision of the Lochner court is a mistaken one. It's a distorted one. It's a vision that doesn't concern the real Lochner case. One of the things that has made this debate more interesting is that Akhil is coming closer to the real Lochner than the one that you've read about in law school that your law professors told you about. Or even the Lochner that Chief Justice Roberts is talking about in his dissenting opinion in Obergefell, where he mentions Lochner 13 times, as though simply incanting the word Lochner is a legal argument in and of itself. That is my mission here, and that I think Akhil and I have our interests are somewhat aligned. And in that world, it's the individual who needs recourse to a impartial adjudicator in the form of a federal judge to protect the individual against organized groups who are able to secure special favors for themselves in state legislatures.
And one 30-second maybe note of agreement. There was a case Judge Higginson was involved in involving, I think, religious coffin makers. I had some sympathy with the libertarian-ish claims that actually did prevail in that case. I don't think I've read the hair braider case, but I've read accounts of it, maybe on the Volokh conspiracy, and this did not seem to me outlandish. I did think that the attack on individual mandates is somehow in themselves egregious was a bridge too far.
We've got some time for audience questions. I see one over here, and some mics are going to travel to you. We have one in the middle. There's a hand. You see that? Yep, somebody's coming towards you. Please, a reminder, a question always ends with a question mark. That's how you know. And occasionally one sentence introduction to your question is permissible, but please no monologues.
Sure. So I want to start with this agreement that there is a role for the judiciary to subject some scrutiny in terms of evaluating this. Is that agreement that at least Harlan's approach is plausible? And for developing public acceptance, what would the language be for recognizing that you believe the state's judiciary should do this, but what would the language be for a state constitutional amendment to sort of restore these protections and require the courts to put in the scrutiny? So what language would each of you put in for that?
I'm not sure I understand the question.
That's why I deferred to you.
Sure. So in order to put state courts back in the business of evaluating whether a particular law is arbitrary, what sort of summarizing, would you just take George Mason's language, what language would you like to add to state constitutions to help get them ratified and win the public argument that this kind of scrutiny should be done by courts?
Well, I think the traditional language of irrational and arbitrary is the correct language. In fact, the so-called modern rational basis test is building upon the traditional rationality inquiry. It just does the Holmesian approach of simply saying that as long as any reasonable person in the universe thinks this is okay, it's constitutional. But it's still trading or borrowing on the historic argument about rationality. Rationality requires some means ends fit, and the end has to be an appropriate end of government. And that's some of what the disagreement is between Akhil and me as to what is the appropriate end of government and how we would figure out what the appropriate end of government is. Then that's something that would take us beyond this debate. But that is the main disagreement you're seeing between us. And arbitrary in the sense that it's being applied to some people, but it's not being applied to other people who are similarly situated, suggesting something untoward is going on. In fact, the current doctrine, ever since Williamson v. Lee Optical, and this is something that Justice Douglas promoted, is that, legislatures can legislate a piece at a time. It doesn't, they can legislate this person over here. They don't have to legislate that person over there. They can just handle things a piece. That's just a way around the historic constraint on arbitrariness. It is arbitrary to legislate this person over here without also restricting the same kind of conduct by that person over there. And that's the sort of inquiry. So if anybody wants to see what the sort of inquiry that I would like to see done, how it would work, look at the lower court opinion in Williamson v. Lee Optical and how the three-judge panel evaluated the law that restricted an out-of-state corporation who really was not in a position to defend itself in front of the legislature. That was the Lee Optical Corporation. How it evaluated the rationality or arbitrariness of that law, even giving the lawmakers the benefit of the doubt, which they did in that case.
Akhil, did you want to speak to that? Or?
I'm fine.
We had a question over here. Mark.
Mark Chenoweth, New Civil Liberties Alliance. A couple of years before Lochner, the same Supreme Court upheld an 8-hour maximum workday for public contracts in the state
Correct.
of Kansas, Atkin v. State.
Yep.
And so my question for you, Professor Amar, is if the Lochner court was anti-redistributionist, then why did it uphold the state law in Kansas? And my question for Professor Barnett is, does the deference to the legislature that was shown by the Supreme Court in the Atkin case suggest that deference to legislatures predated the Holmes dissent in Lochner?
That was the last thing? The
The deference predates the Holmes dissent in Lochner.
So the majority opinion in Lochner has no good distinction for the Kansas case, which is highlighted by John Marshall Harlan in his dissent. And remember, I'm with the dissent. Okay, so you're making my point. It is not the case that the court in every single area, as has been mentioned, was sort of always on the wrong side. But in a lot of cases, they're striking down minimum wage laws and maximum hour laws and plausible safety laws and redistributive tax laws. And they're not doing it everywhere just because, actually, if that's irrational, that's a great mass of legislation, and every so often, in fact, more than every so often, they let stuff through, but they, deep down in Lochner, think this is wrong, and I think it's permissible to try to actually, for example, have a tax code that's modestly redistributive. And that tax code has lots of arbitrariness in it, the one that we have today and the one that we're going to have next year, and I don't know if Justice Barnett is going to invalidate all of that.
Well, actually, I think it's important, I should have probably said this earlier, I think it's important to distinguish between redistribution that happens by means of taxing and spending and redistribution that happens by restricting the liberties of some as opposed to others. The Lochner case involves the latter. It doesn't involve the former. And I think there's really no doubt that going back all the way to the founding, there were poor laws, for example, at the founding. So there was redistribution at the state level. The founders found that there was a problem with that because there was a lot of free riding and cheating involved. So they then developed workhouses in order to say that you had to work if you're going to get support. But the idea, this was all, of course, redistributive, but it was using the power of taxing and spending in order to redistribute, not using the power of regulation. And Lochner today is a case not about redistribution. It's a case about economic regulation and whether there needs to be judicial scrutiny to ferret out pretext. That's the Lochner case that I'm talking about today.
We have a question from David Bernstein, author of Rehabilitating Lochner.
Rehabilitating Bernstein.
This is like 50-yard seats for the Super Bowl for me, so this is great. 30 years ago, almost 30 years ago, I attended my first National Federalist Society Symposium. If this had been the topic of debate, it would have been nearly impossible to find someone on either side of the political spectrum who have taken the not crazy position. And here we have two of the greatest stars of the constitutional law world from either side of the political spectrum arguing at least that Lochner wasn't crazy. So I would just like to ask Professor Barnett and Professor Amar to comment on what this tells us about the development of the Federalist Society, conservative jurisprudence, the future of economic liberty, how constitutional change happens more generally, anything like that.
You want to go first?
In the long run, I do think the law tends to work itself pure. We say freedom of speech and freedom of the press, and then we don't do it. We have the Sedition Act, and it's upheld by justices writing circuit gleefully. It's in the 20th century, Oliver Wendell Holmes, for a unanimous court, is willing to say Eugene Victor Debs, the guy who gets 1 million votes for president, should go to prison for 10 years for basically criticizing the war. And it really does say freedom of speech and of the press. And eventually, the Warren Court, you see, catches up with that. And it really does say, actually, incorporation. Senator Howard said it, and Bingham, and lots of others, and the courts aren't doing that. And then the Warren Court eventually does that. These are two Hugo Black themes. 5 times it actually says in the Constitution today the right to vote. 14th Amendment, Section 2, 15th Amendment, 19th Amendment, 24th, 26th. And the courts aren't enforcing that. See Justice Holmes in Giles v. Harris and other cases. But eventually we catch up to that. Actually, there really is a 10th Amendment. And when I'm in law school, people kind of forget, had forgotten about it. But it really does say it. And it has made a revival. When Randy and I and Eugene Volokh and others are first starting to write about the Second Amendment, there's not a lot of case law at the Supreme Court level about it, but it's made a revival. The thesis of America's unwritten Constitution is, in the long run, the written text actually is important, and when stuff is really kind of way out of sync, like Holmes, who says, the 14th Amendment, and the Constitution does not enact Mr. Herbert Spencer's social statics. And it's great, iambic meter, does not enact Mr. Herbert Spencer's social statics. It's great poetry, I get it. But Mr. Justice Holmes, what does it enact? You see, and he doesn't tell you that. And in the long run, my view is actually the case law eventually begins to correct itself a bit. And so it's a little like Princess Bride, that the text it may be mostly dead, but it's never completely dead, and it always has this possibility, with the right kind of kiss, to be revived.
Randy, would you like to?
Yeah, I think this actually is a significant indicator of what's happened over the course of 30 years with the Federalist Society. When the Federalist Society was just getting going, the primary mantra that existed amongst conservative lawyers was judicial restraint. And it was a mantra that they essentially got from the progressives. The post-New Deal court was split between the old-fashioned progressive restraint judges and the newfangled judicial activist judges, and that distinction, in fact, the term judicial activist was coined by Arthur Schlesinger Jr. in a 1940s article in which he distinguished between the lions of judicial self-restraint on the one hand, like Frankfurter, and then the new Yale activists. He associated with the Yale activists and the legal realists on the other hand. And the federal and conservative judges, conservative lawyers, conservative movement people associated themselves with the restraint side of the post-New Deal court. And then what happened in the 1980s? Ronald Reagan was elected, and Ed Meese came to town. And Ed Meese gave his famous speech to the ABA, and in that he articulated a twofold agenda. One was restraint, proper restraint, so restraint hadn't been dropped, but the other one was originalism. The original meaning of the text is what we should follow. That was not an emphasis amongst conservative lawyers prior to that. It became an emphasis then. Justice Scalia also continued to make it an emphasis in what he was writing about. And as a result of that is when we're talking, we then start to notice that there are many clauses of the Constitution that say what they mean, and they are not ink blots. And they need to be paid attention to. And it is not somehow improper for judges. It is not a violation of some ethic for judges to try to enforce the entire Constitution, including the parts that protect individual liberty better. And so what's really happened, I think, is that the originalism textualism part of the conservative agenda, which we heard so eloquently last night from Don McGahn when he said the philosophy of the judges that they're going to try to put on the court can be summarized in two words, originalism and textualism. There's no surprise that if you stress originalism and textualism, you're going to get a more active judiciary, but not an activist judiciary in any sort of pejorative word. And I think it is the originalism having gotten traction over 30 years that has changed the discourse in the Federalist Society for the better.
Unfortunately, we're almost out of time. I thought it might be nice for us to end with a thought that I hope we can all agree on. This is a passage from Lochner itself. So that, as Akhil points out, they were at pains to emphasize the working conditions of the bakers, but the court says, well, but it's unfortunately true that labor, even in any department, may possibly carry with it the seeds of unhealthiness. A printer, a tinsmith, a locksmith, a carpenter, a cabinet maker, dry goods clerk, a bank's, a lawyer's, or a physician's clerk, or a clerk of almost any kind might come under this under the power under this assumption. In our large cities, there are many buildings into which the sun penetrates for but a short time each day, and these buildings are occupied by people carrying on the business of bankers, brokers, lawyers, etc. It might be said it's unhealthy to work more than that number of hours in an apartment lighted by artificial light during the working hours, the occupation of the banker and the lawyer, etc. Might be unhealthy, and I want to say we're thrilled that you've chosen to spend your Saturday afternoon with us, but I do hope over Thanksgiving you will all get some sun. Thanks to our debaters. Thank you.
That was great.
It was great.
Thanks.
Thanks.
I hope the family is happy.